Those are the rules in my court. You can make whatever offer you want to make, but I require that the state make an offer, and then the defendant, whomever it may be, can accept or reject that offer. So there is no people didn't get an offer. Now, I don't know what the state is offering. The state may have a case where they're like, we want the death penalty or we want life. Even if that is their offer, I still say you need to make it to the defense. So
welcome to the bench of justice.
Court is calling 2017 CR 13555, State of Texas versus Michael Fernandez. Could I have parties approach for the record? And if you could announce for the record, please state.
Steve Del Prado for the State of Texas.
Defense.
Patrick Valentine for Michael Fernandez.
All right, the court is in receipt of defense's motion for judicial clemency and the state's response to the defendant's motion for judicial clemency. Since there's a response, I'm making the logical assumption that the state has received your motion and both parties are ready to proceed. Is that correct?
Yes, Your Honor.
All right, defense, it's your motion.
Thank you, Judge. If I could just take up first the state's response. Mr. Prado responded regarding the court's jurisdiction because I believe the system doesn't really accurately reflect when Mr. Fernandez was actually placed on probation. He's in fact still on probation. He has not been terminated. That's part of what we're seeking today. And Your Honor's jurisdiction extends 30 days after the day of that termination to grant judicial clemency. So I don't think that argument applies, but I understand why it was made given the confusion of the system. But addressing the merits of our motion, Your Honor, we are here today seeking judicial clemency from the court. We're asking the court to vacate Mr. Fernandez's conviction for tampering with the government record and allow him to proceed better with his life. Your Honor may remember this case. I think it was probably among the first that he tried after taking the bench. And in that case, Mr. Fernandez was accused of 4 crimes involving official misconduct. The first 3 had allegations of an assaultive nature regarding Mr. Fernandez's treatment of in a particular inmate. He was acquitted on those 3, but the jury did return a verdict of guilty on the remaining count of tampering with the governmental record, and that's the misdemeanor version of that offense. For that, they assessed a punishment of 0 days in jail and a $1,000 fine, and Your Honor placed him on probation for a period of 6 months. So then I took the case up on appeal. Unsuccessfully, it comes back down, and then we had a little confusion trying to get him on probation, finally did. And so that's why it's taken so long to get back in front of you, Your Honor, at this point.
No problem.
But I'd like to present the testimony of Mr. Fernandez, and I think first Mrs. Fernandez, to convey to the court what these last 3 years have been like with the burden of this conviction on his record, and how Your Honor may be in a position to provide this family with a better way forward if you were to grant him judicial clemency. So if I could start.
And before you start with that, I'm assuming, State, are you objecting to this?
Yes, Judge,
All
we
right.
are. I have a couple of comments with regard to the time frame.
Yes.
And I first want to let you know that in the state's response, I do make a mistake of saying that his probation had ended. It seems confusing on what's going on, but this is in the state, you may have it in your file, Judge, but the original terms and conditions of community supervision were signed by Mr. Fernandez on March the 19th of 2019. So we do allege that his actual community supervision started that date. And when the final mandate came down, when the petition for discretionary review was denied, that was in November the 19th of 2020.
Yes.
And so we believe that by operation of law, his probation then ended 6 months after that, because kind of almost like 5 months after that, because he already started in March of 2019. So even though I know Mr. Valentine had said that there was some confusion of getting him on probation, he signed his conditions of community supervision probation here in this courtroom on the date that he was found guilty of the actual offense of tampering with the governmental record. So it's a little confusing as far as what the dates of when he started and when he stopped would be, but we believe that he is presently off probation. I know that he shows that he went back in December the 26th of 2021, a year and a month later, after the mandate came down, and that he is still, I think, showing that he's actively on probation, which would mean that it wouldn't be timely filed if he's actively on probation, because you can't grant judicial clemency until it's terminated. But let's assume that he's terminated. So there's a little confusion, and the law isn't very clear about when that jurisdiction ends. Our initial response was thinking that he had already terminated back, and it appeared that he had terminated satisfactory, but that actually was his bond conditions terminated. So it was a little confusing for us to look back at the record. So I want to first clear up the fact that was incorrect when we said that his probation terminated in March of 19. What we do believe, though, is after the mandate came down, after he appealed this jury's ruling to the fourth court, and after the petition for discretionary review was denied, that was November the 19th of 2020, his probation would have, by operation of law, begun again, since he'd already signed his conditions in November of 2020. So that would mean that his probation would have been terminated, or the court's jurisdiction, by approximately, it's another 5 months to that, April and May of 2021. So that's kind of the first issue that we have.
All right, what the court has in the court's file is that conditions were signed on December 13th, 2021. Is that what everyone has? Because that's what I have in the court's file.
That is what I have.
Well, Judge,
I know he initially signed one right after the trial, but then when we
Yes.
took appeal, that was stayed.
Yes. So once they went up on appeal,
yes,
then what ended up happening is he wasn't placed, technically, he wasn't on probation, he was appealing. And so I didn't enter my orders until I think in December, and he was actually placed on probation, and he actually signed his conditions on December 16, 2021. And it came back to me to sign on December 7th, 2021. So that's when I signed his conditions of probation. Is that not what everyone has?
That's when we believe his probation commenced.
All right.
Because that's when he was actually.
All right, so here's my question, and this is where I am because I want any testimony that I hear to go to the issue that I'm looking at. So I've read the state's response, and I've read your motion in great detail. And my question is going to be, how is the person who's standing before me, Mr. Fernandez, any different than anybody else who has a tampering with a government record? And they're on deferred for it, or regular probation. He's on regular probation, but they're on probation for it. How's he any different from anybody else who's never had any criminal history? Because there are some people who have been placed on deferred adjudication or regular probation for tampering with evidence, and they never had any criminal history before they had a tampering with evidence. So my question would be, how's he any different from those people who have that as well?
And we intend to demonstrate that, but I would also say I don't believe that judicial clemency is a procedure that's utilized enough in Texas. It's something that gives your honor discretion to actually make a difference in people's lives and give them back some portion of their future. I know this administration purports to be all about justice reform and all that, but I see too few lawyers and too few judges, frankly, considering judicial clemency as a possibility at the end of regular probation. But that said, I would like to present testimony that I hope will convey to the court how these are very good people and they were seeking to live a better life. And this conviction is an encumbrance on that. And by removing that encumbrance, Your Honor, you not only vastly improve the conditions of the future for this family, but also make society just a little better by allowing Mr. Fernandez to resume a role as a fully contributing member.
And I think, State, are you going to not stipulate that these are good people?
Yeah, and you're absolutely right, Judge, and I don't disagree with anything Mr. Valentine has just said, that I'm sure Mr. Fernandez is a good man. The concern I have is that as the state, was a jury of 12 people in your court, as you'll recall. And
Yeah, it
I'm
was,
sorry.
yes,
It was 6.
Yes.
I apologize.
with 2 alternates,
Yes,
because I always do an alternate.
it's true.
All right, then we'll,
And so I will agree with all of what he said about that, I'm sure he's a good man. I don't see where there's any difference between anybody else who has remorse over the fact that they were convicted. And again, when the state had given the opportunity for deferred that was not accepted, he could have already had a non-disclosure on this, which would have put him in a very different position than he's in today.
Well,
These are choices that were made that I appreciate. In hindsight, you wish you hadn't have made.
well, I will tell you, the court will disregard any plea negotiations that may or may have happened, because the court is not aware of those,
And I understand that, Judge.
and the
but
court
when
will
somebody's
continue to be
asking-
unaware.
But when somebody writes letters asking for clemency, saying that their choices that they made by following their attorney's advice that they wish they hadn't have made, to me, that brings that issue up.
I don't believe that's her position. I mean, let's remember, he was acquitted on 3 of the 4 charges here. I mean, he had very good reason to go to trial on these cases. He couldn't parse them and choose them out. And as Mr. Fernandez will testify, no offer was ever conveyed to him. And I don't think it was ever conveyed by the state.
Well, this is what I will say. I will say that in the 187 District Court, I make sure that the state makes an offer in every case, because those are the rules in my court. You can make whatever offer you want to make, but I require that the state make an offer, and then the defendant, whomever it may be, can accept or reject that offer. So there is no people didn't get an offer. Now, I don't know what the state is offering. The state may have a case where they're like, we want the death penalty, or we want life. Even if that is their offer, I still say you need to make it to the defense. So I don't let anyone walk away from this court not having been tendered an offer.
And I believe I did say an offer was not conveyed by the state. I retract that. I have no idea. All I'm saying is Mr. Fernandez does not remember an offer being discussed with him. And again, frankly, he beat 3 of the 4 charges. He had very good reason to go to trial. This isn't a buyer's remorse situation.
Yeah.
Well, if I could just speak to that briefly.
Okay, just 1 second. Defense, off the record for a moment. Mr. Hernandez,
Yes, Your Honor.
have you finished with your selections?
Yes, Your Honor.
All right, are we ready? Have you,
I didn't see that.
all right, have you turned them in, Mr. Hernandez?
Not yet, Your Honor. I was just thinking that.
All right, so let me ask you all, because I don't want to keep Brendan here too long. We are, we're starting jury trial tomorrow at 9:30. How long do you expect your 2 witnesses to be?
5 minutes apiece.
All right, are you able to be here tomorrow? I'll need you all here at 9 though, because I want to start the jury immediate at 9:30. Are you all able to do that? All right, if you're not, let me know. We'll put it on a different date.
We want to get this done, so I think we can do that. We appreciate
All
it.
right, just make sure you're here at 9. Otherwise, if you're not here at 9, I'll still get to it, but it'll be during a break.
Yes, ma'am.
Okay, thank you so much for coming. Thank you.
Thank you, Judge.
Thanks, Judge.
Sure.
When you slowed down, I saw her face relax.
All
Poor thing. She gets on autopilot. right?
The courtroom falls quiet as the judge calls the case, State of Texas versus Michael Fernandez. But this isn't a trial. This is something far more personal, a fight for a second chance. Fernandez stands before the court, not to argue innocence, but to ask for judicial clemency, a request to erase his conviction for tampering with a government record. Years ago, a jury cleared him of 3 serious charges, but found him guilty on 1 count. His punishment? No jail time, just a fine and probation. Still, That one conviction has followed him ever since. His attorney steps forward, arguing that this mistake shouldn't define his life. He tells the court that Fernandez is a good man, a family man, someone trying to move forward. The conviction, he says, is holding him back from jobs, opportunities, and stability. But the prosecution isn't convinced. They push back hard, saying there's nothing unique about this case. Plenty of people regret their past. Plenty wish they could erase a conviction. So, why should Fernandez be any different? Then comes the moment that shifts the room. The judge leans forward and asks a simple but powerful question. What makes him different from everyone else? Silence. Because in that question lies the entire case. This isn't about sympathy. It's about fairness. About whether one man deserves something others don't get. With time running short, the judge makes her decision for now. She wants more. More proof. More testimony. More reason to believe. The hearing ends without an answer, but with everything on the line. Tomorrow, Fernandez returns to court, where his future could finally change or stay the same forever.